Hey everyone, this is Steven from Campus Inc. back with another episode of the NIL show. We have an awesome guest today. Back with us is Sean and Adam, and I'll let Adam introduce our special guest. Adam, what's up?
Yeah, we're super excited to be joined by Ben Shrader. Ben Shrader he's got a wide ranging background, both as a trial attorney, but also in sports. So along with being a contributor to Conduct Detrimental, which I think is one of the most brilliant names for a sports law podcast and kind of media organization there. He's spent some time as a broadcaster. He has a wide range experience into labor law, unions, representation and litigation on behalf of NFL players, professional players, and a graduate from DePaul School of Law here in Chicago. And on top of all of that, he sits as the chair of the Chicago Sports Commission here in Chicago. So we're really excited to have you join us, Ben. Thanks for being here.
Yeah, Adam, guys, thanks so much for having me. I'm excited to chat all things NIL today.
It's going to be great. I feel like, with all that you do and all the things that you touch, I couldn't get it all in the introduction, but we're really excited just to have you. You don't really touch the collegiate space directly, right? Like you're not associated with a university, and so we're really excited just to hear your perspective from a little bit of that, like, hey, here's what I see as a trial attorney, as a sports broadcaster, as, kind of this experience in litigation. Here's what I see how this is going from a little bit of an arm's length. So we're really grateful for your experience here.
Yeah, no, I appreciate it. There's all sorts of different people participating in this stuff now too. So it's interesting to see from all these different angles.
So Ben, how did your world change, or how has your world changed in what you do on a day-to-day basis with NIL, and before it and after it? Maybe that would give some listeners just a little color on what you've done in the industry.
Yeah, no, I appreciate that, Stephen. I would say day-to-day things probably haven't been like night and day for me. I as Adam kind of touched on, I do a wide variety of stuff. What has been exciting from my perspective, from a legal perspective, is that, this NIL stuff was anticipated and sort of hoped for a long time. There's been litigation around it for, almost a decade. So those of us who are monitoring updates with regard to name, image, and likeness litigation and college sports and how athletes can try and get compensated, have been keeping an eye on this stuff for a long time. Fast forward to the summer of 2021, and it seems, even to those of us watching and certainly to more casual observers, that everything just blew up overnight. And in a sense, it did, because though the NCAA and others were monitoring it for a long time, there wasn't a lot that was actually done in terms of tangibly, how do we get players paid? How do we get student athletes compensated? Things like that. July 1st, 2021, several states had laws that were either going into effect or about to go into effect. Right around this time, a case came out, which I know you guys have talked about on previous episodes, the Alston versus NCAA case, which wasn't exactly an NIL case, and it wasn't exactly on point to allowing all college athletes to get compensated. But in a lot of ways, both legally and practically and philosophically, it opened the door to all of these opportunities that student athletes are now getting. And so right away, you had all sorts of people that had not previously participated in the industry or in deals like this that were coming out of the woodwork. So from a day-to-day perspective, things I think have stayed busy and gotten a lot busier for people that have been involved in this kind of stuff. From a more sort of big picture thing, it's exciting in the legal field. Anytime something comes up that's not really well settled, that's relatively unusual. You saw already how long these cases go to take to get through the court system. It seems like things take forever, and they do. We're kind of used to it. And so when things are kind of more new and there's more opportunities and it's more of a blank kind of canvas, that's really exciting, because that kind of stuff doesn't come around as much in our field as it does in other fields. So I think from, how have things changed? I think that's the biggest, part of it, that excitement level that comes with getting to participate in something that's still being created.
When it comes to fair market value, I feel like fair market value is a major topic here. And I'm curious, how many situations have you come across before where there hasn't been an existing market before prior to something like this happening? And then also determining what the heck is fair market value for these collegiate athletes. Because I feel like there's a lot of people that's getting tossed around and nobody really knows exactly what that value is.
Yeah, it's a really good question. The quick answer is it hasn't been answered yet. We really don't know. The fair market value thing is a huge topic because, NIL deals have to have some fair market value in them. They have to have a quid pro quo, i.e. services rendered. You can't just give athletes money to come to school or to be in school. There's other sort of rules attached. The fair market value is subjective. One, there's really no consistency on who's deciding that or how they're deciding that. I haven't seen a lot of things, if any, being rejected, these deals for not being of a proper fair market value. It's not like we have, like you said, an established, price for a lot of these services. There's some corollaries, when you're talking about the sort of ideal and probably most common deal, which is the social posting and the Instagram posting and things like that. There are matrices and for certain types of deals, but they're not exactly the same. And so you're kind of, again, with a lot of this other stuff, making it up as you go along. And so, I think those things, like a lot of other things, both in deal making and in the law and, in sort of similar industries, will get established. There'll become kind of an accepted, value for certain services. But right now, again, I think people are just kind of making it up as they go.
And if somebody wants to give an athlete $5,000 to sign something, is that the athlete's fault? I mean,
right. And it's, we talk about it in terms of contract negotiations. Say a guy's a free agent in the NBA, what's he worth? What one team will pay him,
Sure.
And so fair market value, if, this whole thing, I'm glad you raised the point too, because a lot of this stuff is about that. It's about the free market. It's about the fair market. What might be worth $5,000 to one school or one company is going to differ, obviously, all over the place. That's not unique. That's every industry, right? So, why it's valuable to you and how much it's worth to you, there's going to be a lot of different reasons for that. And so, what is it worth? Exactly. What's one person willing to pay for it? Why should the NCAA, why should a state law interrupt that? They don't interrupt that kind of stuff in other industries. So it goes to, I think, the point of people just aren't used to this kind of stuff with college athletes. The NCAA is so set in its old, out of date ways that it just can't wrap its head around, I think, sometimes these kind of deals. Like, well, we've never done that before. How are we going to figure that out? It's like, well, how every other industry and company figures it out. It's what the market will bear. And I think it sort of highlights how much of this stuff is kind of complicated by its newness and its, inconsistency in its enforcement. But a lot of it is also really simple and something that everyone does all the time in regular business. And so, I think it's one of those things where if we had this conversation a year from now, a lot of this stuff would be more established 2 years from now, 5 years from now. But right now, you're right. It is a simple thing, but it's a really hot topic, especially the who gets to decide part.
And I think it's the who gets to decide that is the most interesting, right? Because, a player is still not, a college athlete is still not paid to play. And so that is the one fundamental difference. A lot of people have asked me, well, is this the same as the pros? Well, no. In the pros, you have an NBA contract. You're being paid by, the organization you play for. So it actually creates more of like this black hole of, well, how then can they make money? Okay, well, can they get an autograph for 5,000, 10,000? Why not 100,000, right? I guess, do you foresee the NCAA putting in like an NIL panel? Do you foresee a collective bargaining, players unions? Like, how, if you were to draw this up and look in a glass ball and say, this is how I think it's going to go down based on what I've seen, what would you say?
I think eventually, I've always been one of those people that I think eventually the schools will start paying the players directly. I think a lot of this stuff is a first step. And a lot of it's changing more quickly than I would have anticipated in some ways. And that's, I look at the NIL as it kind of stands now as the first step in like correcting a wrong that was perpetrated for so long. For so long, college athletes were essentially singled out and not allowed to do uh, certain things, be compensated, move freely in the market, um, commensurate with their value. Obviously, especially in the revenue generating sports for decades, um, these athletes were the primary driver of huge amounts of revenue that went to, in most cases, everybody but them. And so this, kind of ability on the margins to sell the autograph, a lot of the stuff you guys are doing with the jersey sales is really cool. And I've always looked at like the jersey as the platonic ideal of the NIL kind of thing. It's like you watch, your team play, you go to the team store, you want to buy a certain jersey. Oh, there's a, University of Illinois jersey with the number 7 that happens to be the quarterback's jersey. You know what you're buying. You know what you want to buy. The school knows what it's selling you, but that person's not allowed to have his name on the jersey, and he's not allowed to make any money off it. It's just the height of unfairness, and it always was. And so I look at this as like step one. And what it's started to do, I think, is change the perception a little bit that, oh, if they start making money on this, the whole world's not going to fall apart. The whole, college athletic scheme is not going to fall apart. The ratings are still huge for March Madness. The money is still rolling in on the TV deals. I think once they figure that, okay, this is not going to destroy us, then it'll be like step by step. Now, the collective bargaining and stuff, the athletes as employees stuff, I think will take at least a few years to work itself out. But I think ultimately, if we're looking down the road, I think that eventually, you're going to see athletes getting paid directly by the schools, and you're already starting to start to see kind of the framework for how that could work, even in terms of colleges being able to participate in NILs.
We see that kind of happening a little bit already in California, right? With some of the new laws that they're proposing about revenue share and things like that. What I'm curious about, and we've talked about this a number of times on this show already, of there really are two worlds of conversation happening in the NIL space. There's the basketball and football conversation, and there's the everybody else conversation. We know why that is. We know that they're the two programs that generate revenue. But from your experience, especially in employment law and understanding how these things work, how do you see that kind of playing out? You can't make precedents or standards for football and basketball that are the exact same for track and field, right? Like, how do you see the universities navigating some of that?
Yeah, that's why I think partly that the free market idea is an important one. And if we look at the NIL as a system, as putting athletes in positions they always should have been in terms of compensation and in terms of being able to capitalize on their notoriety. I think that for football and basketball particularly, those are always going to be the drivers because those are the major revenue sports. There's going to be some outliers. There's a number of very popular athletes that are either gymnasts or volleyball players or tennis players. I think you'll see some of those individuals be able to monetize this as well. But if you look at it solely from the idea of marketability and what's fair and being able to capitalize on what you can capitalize on, most athletes were never going to be able to do that anyway. And so I don't think that should be against the law. I don't think it's particularly unfair. Treating everyone fairly doesn't mean treating everyone the same. The quarterback of Alabama is always going to be more marketable than a track and field athlete at a D2 school in the Midwest. That's just the way it is.
Right.
And so, I think the students understand that. I think the athletes understand that. So in terms of the NCAA regulating that kind of stuff differently, I think a lot of practically what happens will kind of come from the business aspects of it. They'll find a way to make the legalities work out. I don't think it's ever going to be unlawful to have, a regulatory system that, it treats people fairly, even if they're not, making the same kind of money.
Well, that's so
it'll
funny.
it'll always be the kind of people that we're making money. And it's, if we use the tennis example, for example, the top tennis pros are making a lot of money, and everyone knows who they are. And, they're very kind of ubiquitous, Serena Williams, Roger Federer, like, those people. Most people that aren't huge tennis people don't know the 100th ranked player, and those people aren't making nearly as much money. And that's because that's what the market bears. And I think that will be what you'll kind of see in the college stuff too. It'll never be equal because it probably never should be, but it'll be a lot better than the way it should be, or the way that we used to be. And it'll be a lot more, I think, fair and in terms of, comparable to other, markets and other industries.
And the other thing about it is there will be opportunities in that model where, yes, maybe that 100th ranked tennis player won't make as much, but they will have an opportunity. If they are really good on TikTok, for example, the cream will rise to the top. It's just like any average student on a college campus. Say it's Steven who was on his at Illinois slinging t-shirts. Like those entrepreneurial people kind of just rise to the surface anyway and emerge. I'm curious from a student athlete perspective. It's interesting talking to student athletes because there is the small percentage that do have agents. But for the majority of them, their agents are really just their parents or a close friend who they trust. And so they have contracts that are coming across to them and they're kind of showing them. And but they really don't know much about legalese and different things like that. Do you have any advice for a student athlete who is looking at a contract, sort of things that they should be on the watch for?
And perhaps they can't go to their school yet for help.
Yeah.
Yes. To bring up kind of the second thing first, I think this is where the schools are going to have to, and I think will step in and either directly assist, facilitate these deals, or, point them in the right direction. I think it's going to be incumbent upon the schools, to help educate them. I would always give the advice to the student athlete, everyone knows at least one lawyer, right? And at least have that person take a quick look at the contract, because, some of these companies are, predatory in dealing with student athletes like they would be dealing with any other kind of student probably, and or any other kind of money-making venture. If it looks too good to be true, it probably is. Have a lawyer look at it for even 10 minutes or 20 minutes just to go through and say, okay, this sticks out. This is really bad. You might want to look at it. Because if it's a deal worth signing at all, it's worth having an attorney look at. And it'll probably end up costing you less in the long run to have somebody look at it for a half an hour. And if it's not, and you don't feel good about it, it's probably not worth pursuing in the first place. That's where it's, I think, going to be incumbent, and we'll probably talk about this because some of the states are changing their laws, and Illinois did something really interesting this week. It'll be really important for the schools to step in and have resources for the athletes when they're dealing with this stuff, because none of them have ever, dealt with this issue before. Having a contract for stuff, especially personal services contracts, where if you don't do this, you get in trouble and you're breaching your contract. That stuff sounds really serious, and usually it is. Most of these deals are not for millions of dollars, let alone, 6 figures or even 5 figures. Most of these deals are much smaller. And so, it can be even scarier. It's like, I'm not even getting that much out of this. Am I going to get in trouble for this kind of stuff? And so I think it'll be really important for, just like any other type of education, for the student athletes, coming on them to seek out education, seek out resources, and frankly, for the colleges and universities to provide them.
Ben, can we touch on Illinois and what they've done the last couple of days? I think some really cool stuff. If you want to kind of tell us kind of what Illinois has been going through and what happened in the last week, that'd be awesome. Yeah.
So Illinois has had a NIL law pretty much since this stuff all started, coming around last summer. It was a fairly typical law in that it had certain requirements and had certain prohibitions, stuff the kids had to do, like report deals to the school. They were allowed to work with agents or attorneys, things like that. It's pretty simple as far as, statutes go, a few page statute. And it was, pretty straightforward. And again, there's not been really much litigation over it because less than a year is no time in the legal system. But what they did this week, and what I think a lot of other states will start to do, is they started to see kind of how things are working out in real life, and they amended a couple real interesting provisions. One of those is, we talk about fair market value being the hot topic. The hottest topic right now is boosters and booster collectives and how they relate not only to NIL deals, but now recruiting, and what are they allowed to do? What are they not allowed to do? And how are they sort of getting around it? The Illinois law used to only, no NCAA rules really allow boosters to get involved in recruiting. That's a no-no. I think that's probably the most basic no-no that we're all familiar with. And that's even for the pro NIL type people. I think they're okay with limiting boosters' ability to recruit student athletes to colleges and things like that. There's got to be a line drawn somewhere. And I think that's a line people are pretty comfortable with drawing. And so the schools didn't used to be, I think to answer really the important question is, the biggest change, or one of the most important changes in the Illinois law, is that schools are now able to facilitate deals where they had to basically stay out of it before. The schools aren't allowed to pay the players directly yet. I think eventually they will be, but now they can at least facilitate and participate in deals in Illinois, not only for current students, but prospective students. And so I think you're going to see, and I think that the consensus kind of among people that watch the legal aspect of this stuff is that the schools can now kind of replace some of the stuff the boosters are doing with facilitating NIL deals. Like the school can act as a middleman between a student and a company that wants to do a deal with a student, for example, at their university. And so that's a big change. And I think that's one of those things that will start to open another door here and another door there, because the interaction will be just different. It won't just be the schools staying out of it like they have been. And the NCAA is still kind of staying out of it. But now you'll see the schools more involved in these kind of deals. And I think that will just lead to more sort of partnership between the schools and the students in terms of doing these deals.
Yeah.
The other thing that really jumped out to me in this new law, as amended, is that the state is encouraging schools essentially to offer education to their students on matters of financial literacy, brand management, associated life skills. They're certainly not required to just yet, but encouraging them to. And I think that will be one of those things that will be like a recruiting edge and a sale and something for the sales pitch. Come here, and not only can we help facilitate your deals, we'll teach you how to look for these opportunities. We'll teach you what to do with the money once you get it. We'll teach you how to manage that brand, personally. There's all this stuff that goes into it that people don't think about. It's easy to post on Instagram. Or I'm probably aging myself. I don't know if the kids are still using Instagram, TikTok, whatever you're posting on. It's easy to do that. It's really easy to do that. But then, okay, what have I really done?
Right.
Have I sufficiently protected my brand? Have I run afoul of any state laws or NCAA rules? Or was I allowed to use that logo I just posted to my page? The athletes mostly don't really know this, and they don't really have any reason to, because they've never done it before.
Yeah.
And so this encouragement, I think, is big. And I think all the schools are going to end up having to do it. The schools have devoted, I think, relatively little resources to the education and sort of assistance.
Yeah.
Mostly because I think for either they don't have the resources, or they weren't allowed to, or, for a variety of reasons. It's all new anyway. But I think you're going to see a lot of that now too. And I think that's why it was important. I think that's, Illinois has made that change. I think Governor Pritzker signed that amendment, a couple days ago.
Yep.
And then I think other states that have similar provisions are going to either want to or have to do certain similar things.
And I think it makes great sense when you go to the business school or U of I Law or DePaul or wherever that may be. The career counselors, they're helping you get opportunities, putting you in front of people. Like they want you. There's a reason, Deloitte sponsors the auditorium in our college of business, right? There's no reason why that can't have a place in NIL. And to be frank, like the school will have the best interest of the student. There's amazing people in the space, as we met Cam Cox last week, that can look out for a student. I think that's the scariest part. How can you expect a 17 or 18, 19-year-old to look at contracts and to know what to do and what not to do and what's a good deal and a bad deal? Have you seen any deals gone bad so far from your side in the legal system and looking at NIL gone wrong? Have you seen anything wildly out of control?
Yeah, at this point, a lot of it is anecdotal, but I think some of the things you're seeing are, and the bad stuff won't necessarily get publicized. One, because depending on how it's bad, if a deal sort of runs afoul of either that state's law or the NCAA guidelines, neither party is really going to want to be in a position where they want to say anything about that because they don't want to violate the law, they don't want to bring shine a spotlight on something if it wasn't really above board in the first place. But I think anecdotally you're seeing some sort of recurring problems, and one, there's got to be one of the requirements of these deals is there's got to be some services rendered. There's got to be something that the student actually does to get the money. Actually does to kind of monetize their name, image, and likeness. It can't just be a payoff. And so you see a lot of, again, we go to the social media deals. I was reading about something, last week or two where, there's issues popping up with how much control the brands are wanting to take over students' social media, taking basically their whole identity and being allowed to do whatever they want with it. Obviously, that's a huge overreach. Depending on how it's worded in a contract or how it's pitched to them or sold to them, the student is not necessarily going to know that that's way farther than they should let anyone go. Who has the rights to their likeness? Who has the rights to their Twitter account, for example? What the company can do with their name or with their likeness. They think I'm just going to make a post a week and that'll be it and that'll be fine. And then nothing really comes of it. But then you look a month or two down the line, it's like, oh, well, they're asking me to do all this different stuff, but then now they want to do it on their own, and it can get really far down the road. And so, I don't think there's a lot of glaring examples yet of that kind of stuff blowing up, but that's the kind of, things you're hearing people, in the legal industry talk about, those kind of provisions. Other stuff with regard to, I think if we're talking about kind of deals, going bad, or, obviously the booster collectives, if there's going to actually be this effort to crack down on them and enforce the guidelines with regard to them, I think you might start seeing a little bit more ugliness, because a lot of those deals are probably not above board. No. And I think maybe some of the people doing those deals don't completely understand the laws in the states they're operating in. And, there's provisions in those contracts likely that are violative of either the law or the regulations or both. And so I think if there is, the NCAA, I don't think has investigated a single case since the NIL system kind of got up and running last summer. Yeah. So there hasn't been a lot published. There hasn't been a lot of discovery on it. There hasn't been a lot of formal stuff. Everything you hear is from a college message board or from a rumor or, these numbers that are being thrown around. There's not a lot of truthful basis in a lot of them, because there's not a lot of formal paperwork on this stuff yet. And there hasn't been investigation. There hasn't been a one case where it's like, oh, we're starting to see a little look behind the curtain.
That's an interesting thing. You said, it's interesting watching the schools finally being able to put educational resources towards this, which is a silly sentence to even hear, right? Like it's a school and they're just now being able to put educational resources towards this. We talked about, state legislation coming in place, blue sky or federal legislation is inevitable coming down here. It kind of feels like the NCAA is almost just along for the ride, right? Like when all of this came out, they kind of removed themselves from the conversation. I'm curious from your perspective, let's say you're general counsel for the NCAA, and they've kind of retroactively come in and said, hey, we're going to go back and look at some of these particularly egregious behaviors. We're going to redefine collectives are a part of boosters. In a landscape where it seems like, again, they're along for the ride since they've removed themselves from the conversation, how do you see them, or do you even see them kind of reinserting themselves back into having some control over this kind of power play? Like it's so bizarre to me.
Yeah, I think that they're at this point, it's a couple things. They're really afraid to lose that badly and that publicly again. Mm-hmm. And so, they're kind of hesitant to do this enforcement activity. Losing 9-0 in the Supreme Court isn't all that uncommon. It's relatively uncommon for such a high profile case. There's a lot of cases that kind of cruise through the appellate system that go 9-0. Nobody ever hears about them. You very rarely hear about a 9-0 case in such a high profile case. And so I think the NCAA for so long was used to just getting to do whatever they wanted for no good reason, because that's the way they always did it. And they got away with it for a long time. And then they very publicly and very strongly lost. And so now they're afraid to lose again. Another angle to it is the resources too. They're, for a variety of reasons, COVID related cuts to staffing, they're down to a very skeleton enforcement staff. And so last I read, there's like 15 or 20 enforcement personnel left to, handle the entire country, hundreds of thousands of athletes, hundreds and thousands of schools. They just don't have the manpower to really fully investigate all this kind of stuff. And so, they kind of have to pick and choose if they want to. And I think the booster collectives is an easy one. I think if they start looking into this stuff, they're going to find some of these. There's like 100 collectives. I think some of them are probably operating completely above board, not doing anything wrong. You see these, Florida's kind of leading the way on a lot of this stuff. You see a couple in Florida that are very confident they're above board, being advised by, very, skilled attorneys that have been, in this sort of arena for a long time, and are not really afraid of any enforcement actions because they're not doing anything wrong. I think there's a lot probably that should be concerned, because the NCAA hasn't really been enforcing any of its rules. The states haven't really been enforcing any of their laws up to this point. And so, some of these, I'm sure it's human nature that some of these collectives are operating unfettered and, have some things to worry about. I think at that point, if the NCAA starts looking into them and gets, a win or two, so to speak, maybe that emboldens them to start to look into this stuff a little bit more seriously. But they're so afraid, I think, of spending resources and spending capital, both in terms of PR and in terms of money, going after something where there will be guaranteed to be litigation. I think is there's few guarantees. I think the first booster collective that gets kind of blown up or sanctioned by the NCAA or NCAA starts to interfere in some of these deals, there will certainly be a lawsuit filed citing back to the Alston case, citing back to, if there's other cases decided in the meantime, saying, look, you cannot, NCAA, interrupt the free market like this. Supreme Court's already told you that, you're subject to the same laws everybody else is. None of this stuff's illegal, and it'll be a big fight. Yeah. And, fairly, I think not many people will be on the NCAA side, and they're very aware of that, I think, even at this point. Yeah. And so, but there are ways that they can, we talk about, they've gotten beaten in the courts, and they've, the whole system's been turned on its head, and from their perspective. They are still allowed to do certain things that don't run afoul of the antitrust laws and don't run afoul of employment laws. They're still allowed to regulate the competition. They're still allowed to regulate universities. Right. They can do that. And I don't think there's any issues even with the pro NIL people of, regulating boosters and recruiting, and so to speak. So, if they want to try and go at it from that angle smartly and, carve out that little piece of it, maybe you see a little bit more of that. But I think the first sort of, it's a little delicate too. We're kind of jumping around a little bit, but or I am. But nobody wants to see the kids get in trouble either. Right. And so it's like, who are you going to penalize? Yep. The talk is that the schools will be sanctioned because they're afraid of getting into litigation with the well-funded booster collectives. They don't want to punish the students, but then it's like, we're going to start sanctioning the schools. Well, the only people the NCAA has left on their side is the schools, because they're supposed to have their interests aligned too. And so, who are they going to go after first? Right. Are they really going to want to pick a fight with, one of these SEC schools who are trying to drive revenue, threatening to break away from the NCAA, threatening to start their own, conference, entering in their own deals? Are they really going to want to pick that fight? Yeah. That's kind of hard to picture too. And so, you're
in this big catch-22 of not really anywhere to go.
I guess, Ben, what are, from seeing, from having experience in the space, what don't we see coming? We know that there's, collectives and boosters, and, we've seen some drama happening in Alabama and Texas between, some coaches and call outs and this and that. What are you most concerned about if you were to look at what is the threat of NIL? Like what should we be worried about, if anything, moving forward?
Yeah, I mean that's a great question. I think maybe if you're a college football fan, for example, you're a big college basketball fan. You like the way that you want to see the student athletes compensated. You want to see them have more advantages and opportunities they should have always had. But you do kind of like the way things are from a competitive perspective. You like the conferences. You like rooting for your school against its rivals and things like that. I think there's probably a concern among some corners that the NIL stuff will sort of drive some fracturing of that kind of stuff. Not that it will be the reason or the cause, necessarily, but that a lot of these considerations in dealing with, it's going to be kind of an arms race, especially if people are allowed to continue to operate in an increasingly, open fashion. We haven't said, I think we've made it a record on an NIL show without saying the phrase the Wild West. But that's really what it is. You hear everyone, that's the one consistent thing about all this is that that's how it's described. And so, you look at Jimbo Fisher and Nick Saban fighting with each other last week. And, these big schools are just going to keep spending more and more money, and they're going to spend more and more money because it's going to be competition and they're going to have to. Right. Especially if they get to start paying the players on their own. You're going to see a lot of money. Yeah. I was going to say, which I don't think is unfair because they've gotten to keep all that money up to that. So they might as well filter it back to the people that actually made the money.
The scout teams are going to be a little different. Yeah. There's going to be a scout team for NIL of what's Wisconsin doing.
Exactly. So I think the concern, fear, if you will, however you want to describe it, is that it will lead to some fracturing like that. You might see a different playoff system. You might see some of the bigger conferences break off. You might see, maybe that stuff was inevitable anyway, but a lot of this sort of paradigm shift is going to drive, change. The NCAA was never going to change unless the Supreme Court told them they had to, right? Yep. And so, I think that'll probably be something that looks different. And so if you are a fan of college sports, sort of how they are philosophically, I think that might be something that would change, either indirectly or directly as a result of this stuff.
Well, there it is, right? That's it. Change is coming regardless. Hopefully it's positive change. We're trying to affect positive change in this space for sure. This has been episode 4 of the NIL show with special guest Ben Shrader, partner of Hart McLaughlin and Eldridge, and chair of the Chicago Bar Association Sports Law Committee. What a wonderful conversation, Ben. We are so grateful for your insights, for your expertise, for your time. I know I learned a lot this week. I hope our listeners did as well. Appreciate you, and we'll talk to everybody really soon.